So, good evening, class. Tonight we will be discussing Chapter 8 of the Law on Sales. We will be talking about assignment of credits and other incorporeal rights. So anyway, to begin, yung assignment of credit is defined as a contract wherein the owner of the credit, which we will now call your assigner, and obviously if he is the owner of the credit, he is obviously a creditor. So anyway, and other incorporeal rights, yung owner nga ng credit and other incorporeal rights will transfer, and the transfer, remember, is either onerous or gratuitous to another person whom we will know as an assignee. So yung ito-transfer ng creditor are his rights and actions against the debtor. So here, with respect to the assignment of credit, the debtor is actually a third person because obviously in the creditor and debtor relationship, siya ay party in interest, yung debtor. But when it comes to the assignment of credit from creditor to assignee, obviously a debtor is a third person. So anyway, other definitions, process of transferring gratuitously or onerously the right of the creditor to the assignee, who will then be allowed to proceed against the debtor. So yun, same, mas simple yung pagkakasabi pero same import. So same idea in short. So anyway, this is perfected in accordance with the provisions of 1475, meaning it is perfected by the meeting of the minds of the parties. So, meeting of the minds of the assignee and also the creditor/assigner. However, class, the assignee will only acquire ownership upon delivery. So, yun ang tandaan natin sa definition ng assignment of credit. So, the nature of assignment of credit is number one, it is consensual because I have said before in 1475, it is perfected by the meeting of minds between two parties. It is bilateral, so both are obliged under the contract. What else? It is onerous because remember, the creditor before receiving yung credit, before receiving the payment from the assignee will have to give up something. So, kailangan niyang ibigay yung kanyang credit. So, unless it is gratuitous nga. And also, in case naman of yung assignee, before he will get the credit, kailangan niyang bayaran yung credit from the assigner. So, onerous. Unless, again, it is transferred gratuitously. Now, it is also commutative or it may be aleatory. It is commutative in such a way, class, na yung assignee will receive, pagka nakakollect na siya dun sa debtor, siyempre, di ba, nagbayad ang assignee to the creditor, an amount for the credit. Now, pagka nakasingil na yung assignee from the creditor, he will receive a more or less equal value of what he has paid, in which case, the assignment is commutative. Now, take note, class, that the assignment may be aleatory. How? If, let us say, yung assignee buys from the creditor yung credit na pagmamay-ari ng creditor against a debtor. So, anyway, binili niya ng mababang presyo kasi ito namang si debtor, ito namang si creditor, he is willing to get rid of the credit, makasingil lang ng mabilis. Yan. Kasi, syempre, kung hihintayin pa niyang matapos yung demanda, etc., etc., it might take a while. So, let us say a credit of 100,000, which creditor has against a debtor. Tapos, merong isang third person or assignee, yan. So, assigns the debt to the assignee and assigns the credit to the assignee. And the assignment is worth, let us say, 50,000 na lang kasi nangangailangan na si creditor, nagmamadali na siya na makasingil. Itong assignee na to, willing magbayad ng 50,000 right now. and si creditor, he will receive 50,000 without going through the motions of a litigation. Why not, di ba? So anyway, ito namang si assignee, syempre, there is for him yung possibility that he might get yung 100,000 from the debtor while paying only 50,000 to the assigner/creditor. So it is aleatory in that sense. Why? Because probably this assignee pays for a meager amount for the credit, and then later on, when he collects from the debtor, natapos na yung case. Yan, if it is there's already a litigation, natapos na yung case. So from the debtor, he will collect the entire amount of 100,000 pesos. So yung value, di ba sa aleatory, yung marireceive mo is more or less. So, your creditor here is actually, assignee is actually taking a risk. Yan. So, but he may receive more or less than what he has paid for. Yan. So, yun ang aleatory nature of an assignment of credit. And mind you, class, probably this assignee will not get anything from the debtor as well later on. So anyway, assignment involves, remember, no transfer of ownership, but merely affects the transfer of rights which the assigner has at the time of the assignment to the assignee. Yan. So, walang transfer of ownership, but remember, transfer lamang ng rights which the assignee has at the time of the assignment. Yan. So, which the assigner has at the time of the to the assignee. So, as a consequence of the assignment, the assignee will step into the shoes of the original creditor. So, lahat ng rights ng original creditor will go to the assignee. So, what else? This assignment of credit may be done gratuitously, as in a donation, or onerously. So if the assignee has to pay for the credit, obviously this is onerous. So if it is done onerously, like in a case of exchange, or in case of dasyon and pago, it is actually really a sale. So tignan nyo it is a sale which does not involve transfer of ownership, but affects only a transfer of credit, yan, or transfer of right. So, yun ang tandaan natin. So, subject matter here in this contract of assignment is the credit or right assigned. Cost or consideration is the price paid for the credit or right unless it is gratuitous, in which case only the liberality of the donor is the cost. What else? And the consent here is the agreement of the parties to the assignment of credit. Yan. So, one important difference daw, sabi sa book ninyo ito transfer, there is a definite third person who is obliged, which is the debtor. Yan. Debtor lamang ang obliged sa transfer of right. Whereas in a sale of right, remember, the subject obliged is the whole world, and which must respect the title of the buyer. So, yun ang main difference nila. So, anyway, let's proceed to 1625, the rules to give binding effect to an assignment. So, as between parties, the assignment is valid even if it is in a private instrument. And there is no specific form required for validity. So, yun ang tandaan natin. So, as between parties, assignment is valid kahit na private instrument lamang ito. Kasi there is no specific form. Remember, it is even a consensual contract. What else? To effect nga lang yung third persons, the assignment must appear in a public instrument. And if it involves real property also, the assignment must be recorded in the Registry of Property or Registry of Deeds. What else? The assignee will step into the shoes of the assignor and yung assignee will acquire all the rights of the creditor subject to all defenses that the debtor may have. So, yung assignee will be subrogated to the rights of the, as well as the obligation of the creditor. So, wala siyang, he cannot acquire more rights than doon sa assigner niya. So, yun ang tandaan natin. So, to be effective against third persons, also, in addition to that, if personal property is involved, a public instrument is necessary to make it effective against third persons. So, as between the parties, wala namang problema. Kahit na private instrument, it is effective against the parties. Now, to affect third persons, i-qualify ko na yung rule number 2. To affect third persons, if personal property is involved, a public instrument is necessary. Now, if real property is involved, again, bukod sa public instrument, there must be registration in the registry of property to bind third persons. Now, also take note that if the assignment is gratuitous, it is actually a donation. So, ano yung sinabi ko noon sa contracts sa Chapter 3, in case of form of contracts, a donation must comply with the formalities of law. So, the deed of donation must be in writing and also in a public instrument, meaning naka-notarize siya. And remember, the acceptance of the donation must be in a public instrument and also notarized. They may be in one and the same instrument, or they can be in different separate instruments. So anyway, in case of assignment, remember, the debtor is not required to give consent, or else itong debtor hindi naman magbibigay ng consent yan to the assignment. So anong mangyayari? The creditor will be stuck with this debtor. Tapos kailangan ng creditor ng pera. Wala siyang paraan para gawing pera yung credit from the debtor. Hindi katulad ng pagka pwede niyang i-assign, siyempre makakakuha siya ng pera from the assignee. So, mabilisan yan. Pero yun na nga, kung bibigyan pa ng requirement of consent of the debtor, sino ba namang debtor ang magbibigay ng consent? Meron siguro, madalang, pero siyempre, yun na nga, consent is not a requisite. Sabi naman din kasi ng law. So, wala tayong magagawa doon. Alam niyo naman, pagka sinabi na ng law, ayan na. Kailangan lang nating sumunod. So, consent of the debtor is not required. But remember, notice to the debtor is required. So, notice is required. The notice is given by the assignee. Yan. So that yung debtor will make payment to the assignee already and not to the original creditor or the assigner. Now, in 1626, this is the effect of payment by the debtor after assignment of the credit. So remember here, class, there is already assignment of the credit. Pero ang pinag-uusapan natin in 1626, is yung notice. Yan ang pinag-uusapan natin. So, na-assign na talaga yung credit. It's not a matter of kung na-assign ba or hindi. Na-assign na. The point here is yung notice. Yan. So, anyway, in 1626, the debtor pays after assignment of the credit, but before he is notified of the assignment by the assignee. So, binayaran na niya kaagad yung creditor. Tapos, itong credit pala, has already been assigned. Pero hindi alam ni debtor kasi hindi pa siya ni-notify ni assignee. So, anyway, payment to the original creditor is valid. So, let us say, creditor, debtor, tapos itong si creditor assigns the debt to assignee. So anyway, itong si assignee does not notify yet the debtor. So itong si debtor naman, thinking na ang creditor pa rin niya, is si creditor pays the creditor before the notice. But remember, after assignment. Yan ang pinag-usapan kasi natin dito eh. So anyway, sabi ng law, payment of debtor to original creditor is valid nonetheless. So, syempre, kung ayaw nang mag-remain as debtor nitong si debtor, syempre, sino ba naman ang gustong may utang, no? Pero actually, meron talaga mga taong gusto nilang hinahabol sila para sa utang. But anyway, that's, hindi, marami lang talaga ako nakita in my practice of 12 years. May mga tao talagang hanggat hindi sinisingil via case in court, yung gusto nilang napapahiya bago pa sila magbayad, tapos sila pa yung galit. So anyway, may mga taong ganoon talaga. So, bahala na sila. So, they want the embarrassment. So, merong mga ganong klase ng debtors. So, anyway, I stand corrected. I've been in the practice for 13 years. Ngayon ko lang na-realize na anniversary pala ng aking pagsasign ng Roll of Attorneys today. So, wow! Happy 13th anniversary to me. Akala mo naman, no? Ang dami ko ng accomplishment. Pero, teaching really is my passion. So, yun naman ang mabuting naidala sa akin ng pagpasa sa bar exam. I was able to teach. May nagtiwala sa akin at kinuha ako na magturo ng TSU. So, anyway, yun ang tanda natin. The original creditor, if the debtor pays to the original creditor, the debtor is released from the obligation. Now, ikaw naman na assignee, aba, binayaran ko yung credit na yan mula sa creditor. Tapos, wala akong masingil sa debtor kasi his payment to the original creditor is valid payment. Ano nga yun ang gagawin ko? Yun ang sabi ng assignee. Sa sarili niya, inisip lang niya. Anyway, nag-consult siya kay attorney. Sabi ni attorney, ay, meron kang right of action against the original debtor. Why? Because obviously, the original debtor is in bad faith. Imagine, he already transferred credit to the assignee for a consideration. Tapos bigla itong si creditor nung nagbabayad si debtor, original creditor nung nagbabayad si debtor, tinanggap pa rin niya yung itong payment. So it shows bad faith on the part of the original creditor. Which is why yung debtor, yung assignee pala, will have a right of action against him. So anyway, burden of proving that the debtor had knowledge of the assignment is on the assignee. So assignee ang dapat na magpatunay na yung debtor is in, barang debtor already has knowledge of the assignment. Kasi nga naman, if the debtor has knowledge of the assignment, he should have paid to the assignee. And if he doesn't pay to the assignee, he may be made to pay again by the assignee. So anyway, letter B, the payment is after notice, after assignment, after notice, or before notice. So, but the debtor had knowledge of the assignment. So, take note here, ang point dito, in letter B, is alam ng debtor yung assignment. Whether or not he was notified by the assignee, or he just knew of the assignment, but there is no notice yet. Point is yun nga, alam ng debtor. So remember here, payment to the original creditor is not valid against the assignee. So remember here, the debtor may be made to pay again by the assignee. So yun ang tandaan natin. So after notice or even before notice, as long as the debtor knows of the assignment. Anyway, remember again here that the assignee should has the burden of proving that the debtor is aware of the assignment. So remember, the assignment is effective as to the debtor only from the time he has knowledge of it. Whether the knowledge is due to notice of the assignee or by some other means. But remember, it is effective only yung assignment from time that the debtor has knowledge of it. So 1627 naman, the extent of assignment of credit includes not only credit but also all accessory rights based on the principle accessory follows principal. But remember, of course, accessories may be excluded from the assignment by stipulation of the parties. So, example in your book, I think this is the example in your book, debtor owes creditor a certain amount of money. Anyway, there is a guarantor of the credit. So let us say 100,000. Debtor owes creditor 100,000. There is a guarantor, or there is a pledge securing the obligation. May nakasangla or merong guarantor. In short, merong accessory obligation. So anyway, the creditor will assign the credit to an assignee. So debtor fails to pay yung assignee. Siyempre, ano na yan, obviously merong na notice, etc., etc. Alam nyo na, may procedure. But the debtor fails to pay the assignee. So, yung assignee may enforce the credit against the guarantor if there is a guarantor, or may foreclose the pledge or mortgage securing the obligation. So, yun ang tandaan natin sa 1627. But in the case of a guarantor, remember, the guarantor may be released if it is expressly stipulated. Kasi itong portion na to, accessory rights shall not be included in the assignment. Pwede daw siyang stipulate siya. So if it is stipulated that accessory rights are not included in the assignment, syempre, mawawala yan. So, what else? Ano pa ba? 1628. In 1628, these are the warranties of the assignor of credit. So, ano ang una niyang winawarrant? Sinisigurado ng creditor that there is an existing credit and that the credit is legal. So, at the time of the perfection of the assignment, remember, merong credit itong debtor na to sa akin, and the credit is legal. So, take note here that the creditor is not liable for the warranty if the credit has been sold as doubtful. So, kung doubtful yung binigay na binentang credit, kumbaga, it is in litigation whether or not such credit exists. So, doubtful, yan. So, the creditor is not even liable for warranty of existence and legality of the credit. So, yun ang first rule sa 1628. Yun ang unang warranty. So, merong credit and the credit is legal. Pero kung sold as doubtful, remember, wala man lamang warranty kahit na ano. So, what else? There is no warranty as to the solvency of the debtor unless it is expressly stipulated, or unless yung insolvency is already existing and public knowledge at the time of the assignment. So, iba class yung sinabi kong meron akong nag-e-exist na credit and legal, there is a legal credit. Iba yon. So, whether or not the debtor can pay or whether or not the debtor is solvent, siyempre ibang usapan. Siyempre, sabihin ko lang, merong utang sa akin si debtor, yung credit niya is legal. Di ba? Okay, I can warrant that. But whether or not the debtor is actually solvent enough to pay, ibang usapan yan. But remember, there is no warranty as to the solvency of the debtor. Yan. Except if it is, number one, stipulated that the creditor warrants that the debtor is solvent. Ay, bilhin mo na tong credit na to, assignee, kasi it is existing, it is legal, and I assure you that the debtor is solvent. So, yan, there is an express stipulation. So, creditor warrants the solvency. Or, if the insolvency was already existing and of public knowledge at the time of the assignment, syempre, magkakaroon pa rin ng liabilities. So, magkakaroon pa rin ng warranties. So, yun ang tandaan natin sa 1628. Also, in addition to that, the liabilities of the assigner of credit or the creditor for violation of the above warranties. Remember, if the vendor or assigner or creditor is in good faith, limited only to the price received and to the expenses of the contract and other legitimate payments by reason of the assignment. So let us say, class, that debtor owes creditor. Tapos itong si creditor assigns yung credit niya to assignee. So anyway, the creditor is, let us say, in good faith. So it happens that the debtor is insolvent. So is the creditor liable for warranties here? So remember, yung general rule natin is that yung creditor is not liable for the solvency of the debtor unless there is an express stipulation to this, or unless the insolvency was prior to the sale or a transfer of credit pala of common knowledge, public knowledge, or common knowledge yan. So what if, class, the credit did not really exist at the time of assignment, or it is not demandable anymore at the time of the assignment? Is the creditor still responsible? So remember here, class, that the answer is the creditor is still liable, except if the credit is sold as doubtful, such as yung credit in litigation, which I have already told you about. So yun ang tandaan natin dyan. So anyway, yun ang rules if the assigner is in good faith. So not liable for the insolvency unless it is stipulated or of public knowledge, and also still liable for the existence and legality of the credit unless sold as doubtful. The rule in case the creditor or assigner is in bad faith, remember, is that liable not only for the payment of the price and all expenses, but also for damages. So yun ang liability of the assigner of credit in bad faith. So in 1629 naman, duration of the warranty for the debtor's solvency applies only if the assigner is in good faith. Gaano ba katagal ang warranty na ito? So take note that the time agreed upon by the parties, ganun katagal. If no time was agreed upon, remember, 1 year from assignment if the debt is already due. Let us say debtor owes creditor, tapos in the meantime the creditor assigns yung kanyang credit to assignee. So let us say, obviously, because the rule requires the assigner to be in good faith. So let us say the creditor is in good faith. So it was agreed that let us say that the creditor will be liable for the solvency of the debtor. So let us say, class, wala ring agreement as to the time element kung gaano katagal yung warranty na ito. So let us say debt is due May 2, 2021. So that is the day of due noong debt, but hindi ito nabayaran ng debtor. Let us say on May 28 ay assigned yung credit. So yun ang date of assignment, May 28, 2021. Until when is this guarantee? Remember, class, that the guarantee is from May 28, 2021 until May 28, 2022. So 1 year from the date of assignment, not from the date the credit is due. Now, if the debt is not yet due, remember, 1 year from maturity. So yung ating problem kanina, debt is due on May 2, but there is an assignment made on April 25. So remember, yung warranty will expire on May 2, 2022. So 1 year from date of maturity if it was assigned before the debt was due. So yun ang 1629. In case naman of 1630, remember these are the warranties of a person who sells an inheritance without enumeration of the things included therein. So this is a sale of future inheritance. Pero remember in 1630, there is no enumeration of the properties which are included. Kasi sa 1347, remember, kung meron kang enumeration of the list of future inheritance, hindi ito pwede. Kasi remember, yung ating successional right, hindi pa naman yan, kumbaga hilaw pa siya hanggat yung ating predecessors in interest, hindi pa sila nagpa-pass away. So, if there is a sale of unenumerated list of future inheritance pa hindi pa namamana. So, remember, this is prohibited. Buhay pa yung predecessors in interest mo. So, this is a void sale. So, anyway, successional rights or the right to an inheritance before partition or present inheritance. Do you see the difference? Here, class, mapakita ko sa inyo. Ayokong kulay na. Future inheritance. Buhay pa, ibig sabihin, yung pagmamanahan. Kinukuha mo na, binibenta mo pa. My goodness, this is prohibited. Bawal. Feeling ka naman, di mo pa naman namamana. But here, present inheritance obviously may be sold. Bakit po naging present? Ibig sabihin patay na yung pinagmulan. So patay na yung predecessors in interest. That's why it is a present inheritance. Also, yung right to successional rights or right to an inheritance, pwedeng benta rin yan. And remember, if it is before partition, it can be sold. So anyway, the sale will not refer to specific things, but here, warranty extends to the fact of heirship. Ako ay isang heir. So yan lang ang winawarrant ng isang tao na nagbebenta ng present inheritance without an enumeration of the things included in the present inheritance. So anyway, ayaw niya. Kailangan ko talagang i-end. So, sale of whole, certain rights, rents, or products. I'm not sure if I have an example for 1630. Let me check my notes. So, anyway, meron nga. So, an heir number 1 or heir 1 and heir 2 are the heirs of the estate left by a deceased individual. Patay na, tulad ng sinasabi ko sa inyo. So anyway, before partition, bago pa nahati yung estate ni deceased between heir 1 and heir 2, yung iba, heirs kasi, heirs, ano ba? So anyway, buhok naman kasi. So anyway, before partition, hindi pa nahati yung estate ni deceased. And without specifying yung definite share in the inheritance, heir 1, sold yung kanyang share to buyer. Yan, let us say for 1 million, yan na lang. So, yun ang bentahan. So, remember class, yung warranty lang ni heir 1 here is the fact that he is an heir to the deceased. Tagapagmana ako ni deceased. Nagmana ako kay deceased. Yan. So, yun ang winawarrant lang niya. He is not liable to the buyer if after na partition yung mga shares, yung natanggap niya is less than, yung matatanggap ni buyer is less than 1 million. Kasi ang winawarrant lang dyan is the fact that that the heir 1 is an heir of the decedent. So yun ang tandaan natin sa 1630. 1631 naman talks about sale of whole of certain rights, rents, or products. So here, take note here that the sale is for a lump sum and yung subject matter is the totality of such rights, rents, or products. So, ang warranty lang ng vendor dito is the legitimacy of the whole and not the various parts or yung mga portions noong whole. Yung parts which comprises the whole, hindi niya winawarranty yung parts, but yung existence ng entire right. So, the vendor here is not liable for eviction of each of the various parts, and unless yung eviction will involve the greater value, part of the greater value. So, a part which is of greater value. So, yun ang mas magandang pagkakasabi dyan. So, example in your book is on point. Hindi ko nababaguhin, pero explain ko ng mas maayos. So, P is a partner in a partnership. Lagi naman ganon. So, P sells his interest in the partnership. So, obviously, P meron siyang ibang partner. Partner 1, partner 2, partner 3. Ganyan. So, anyway, P1 is a partner in a partnership. He sells all his interest in the partnership for a lump sum of 150,000 pesos. So, upon the dissolution of the partnership, so binenta niya kay buyer yung kanyang share. So, obviously, upon dissolution, yung share ni P1, partner 1, will be given to the buyer. So, anyway, yung buyer received after the dissolution of the partnership yung assets ni partner 1, and this consists of 50,000 pesos, some office equipment, and a car. So later on, yung car nakuha ng isang creditor. So ng creditor ng partnership, because this is partnership assets. So partnership assets, ang may preference is partnership creditors. So anyway, remember here that partner 1 is not liable to the buyer because partner 1 does not warrant yung various parts ng kanyang interest or right. Pero ang winawarrant lang niya is yung whole. So ang winawarrant ko lang this, I am a partner in this partnership. And I have a right to receive itong etc. after dissolution, my share after dissolution, surplus profits after dissolution, yun lang ang winawarrant ni partner 1. So, he will warrant that he is his legitimate right as a partner taken as a whole. Yun ang sabi sa book ninyo. But later on, syempre remember, yung car ang nakuha. But if the value of the car, let us say, exceeds 75,000 pesos, kasi in the example in your book, the right was transferred for the lump sum of 150. So, kung yung car na nakuha ng creditor ng partnership / third person is more than 75, so yung interest greater value, yung portion kung saan na-evict yung buyer. So, remember here, that P1 will be liable because the buyer is evicted from the part which has greater value. So, yun ang 1631, including example in your book. In 1632, the liability of vendor of inheritance for fruits received. So, take note here, fruits of an inheritance are included in the sale thereof. So, if by some way, it is the vendor who receives yung fruits, remember, he must deliver them to the buyer of the right of inheritance, so successional rights. So, if they have been consumed, remember, he must reimburse the buyer. If they have been sold, he must deliver the price of the sale unless otherwise it is stipulated. What else? The liability of the vendor for anything received from the inheritance is subject to any agreement to the contrary, which I have just mentioned. Now, take note also of 1633. Vendee is liable for the debts and charges of the estate. So, kung may inabonohan yung vendor na debts and charges on the estate, remember, the vendor has already sold his present inheritance, which is not yet before partition. So, remember, class, that if the vendor is obliged to pay for charges and debts of the estate, remember, he will have a right of reimbursement from the vendee. So, kasi, di ba, sa 1632, pagka may fruits, entitled yung vendee. Now, in 1633, if there are liabilities, obviously, it is the vendee who will be liable for them. So, pagka inabunuhan ng vendor, kailangan i-reimburse ng vendee. Because any benefit naman, on the other hand, if there is benefit, also, it will be for the account of the vendee. So, again, subject to any contrary agreement. 1634 naman, these are the requisites of the right of redemption of debtor in case of sale of credit or other incorporeal right under litigation. So, this is an instance of legal redemption. So, here, tandaan nyo that the creditor sells or transfers the credit to an assignee. And remember, class, that the debtor will have the right of redemption. This is even legal redemption. The law provides for this in 1634. So, applicable only in the case of sale, in case of barter of the credit or a donation of the credit by the creditor, this right of legal redemption will not apply. So, what else? There must be a pending litigation at the time of the assignment. The complaint of the assignor must have been filed, and there is already an answer filed by the debtor before the credit is transferred. So, in 1634, this will apply only to a claim in litigation. So it means yung claim in litigation, a claim which is actually litigated. So, merong dispute, there is contest regarding the claim, and this will happen only if there is an answer filed by the debtor in the case wherein the creditor seeks to collect from the debtor. What else? The right of redemption must be exercised within 30 days from the date that the assignee demands judicially or extrajudicially payment from the debtor. So, if there is no demand from the assignee, the 30-day period will not commence. So, these are what the debtor is supposed to pay the assignee para ma-exercise yung kanyang right of legal redemption of credit. The price paid by the assignee for the credit, the judicial cost incurred by the assignee in collecting the credit, and also the interest on the price from the date of the payment. So, ano bang example nito? So, let us say, creditor sues the debtor to recover a credit of, let us say again, 100,000. So, here, the creditor files a complaint, kaya nga sues debtor for 100,000. So, the complaint has already been filed by the creditor, and yung debtor files an answer to the complaint. So, the credit here is already in litigation. So, now, while the credit is in litigation, the creditor sells the credit to an assignee, let us say for 50,000 na lamang. So, syempre, nagmamadali si creditor na makasingil. So, imbis na maghintay pa siyang matapos yung case, edi ibenta na lang niya yung credit to an assignee. So, let us say, yung credit is sold for 50,000 pesos. So, to avoid delay in the collection, binenta na lamang ni creditor yung credit to a third person. Syempre, itong si debtor may redeem the credit from the third person. What will the debtor do? Syempre, legal redemption to. So, remember, class, debtor may redeem the credit from the assignee by paying the assignee the sum of 50,000 pesos. So, in short, mas makakatipid pa si debtor kung itong niredeem niya yung credit na ibinenta ng creditor. So, anyway, what else? pay yung debtor the sum of 50,000 within 30 days kasi yun ang period of redemption. 30 days from the time that the assignee demands payment of 100,000. Siyempre si assignee hindi naman niya i-demand kung magkano yung binayad niya sa credit. Ang i-demand niya yung halaga ng credit which is 100,000. So, yun ang tandaan natin sa requisites ng 1634. So, yung purpose why the right of redemption is given to the debtor, because it is advantageous to him, because probably the debtor will pay less than the value of the credit assigned, because usually yung assignment of credit is for a lower price. So, if he exercises his right to redeem, syempre makakatipid siya, katulad dun sa example kung binigay kanina. So, to avoid purchase by third persons of credit in litigations for speculation. So, pwedeng i-redeem ng debtor for the price for which it was actually sold, not the value of the credit. In 1635, these are the exceptions to the debtor's right of legal redemption, meaning there is no right of legal redemption for the creditor in the following cases. So, anyway, number one, if the credit is sold to a co-heir or a co-owner. So, this is based on the desire to do away with co-ownership or pro-indivision because, again, the law frowns upon co-ownership. Gusto niya para sa improvement ng, lalong-lalo na if it's property, para mas ma-improve yung property, mas maganda na hindi ito co-owned. Yan ang sabi ng law. So, here, if the right of redemption is granted to the debtor, it will not terminate the litigation, and co-owner o co-heir may still sue yung debtor for the share na nagko-correspond to the former in the credit. So, let us give an example. I think this is also the example in your book. Debtor is indebted to creditor 1 and creditor 2 for 10,000 pesos. So, si creditor 1, let us say, sues the debtor for failure to pay the debt. So, creditor 1 versus debtor. So, if creditor 1 assigns his credit to creditor 2 during the pendency of the litigation, remember, debtor is not allowed to redeem the credit from creditor 2. The credit of creditor 1 from creditor 2. So here, take note, there is one debtor, there are two creditors, tapos the debt is 10,000. Each creditor, yung kanilang share is in the credit is 5,000. So pending litigation, nagdemanda si creditor 1, noong dinimanda niya si debtor to be able to collect on the amount owing. So anyway, itong creditor 1 assigns his credit to creditor 2. So, probably for a smaller price or whatsoever, yan. But the point is the credit is assigned. So, itong si debtor who is interested to redeem yung credit, syempre nga naman, di ba, sa redemption, katulad na sinabi ko kanina, baka mas mababa ang price, yung redemption price kaysa sa value ng credit. Let us say it was sold only for 2,500, 3,000, etc. So, i-redeem ni debtor yan, mas makakamura siya. But obviously here, the right of redemption is not given to the debtor because the sale is to a co-heir or co-owner. In our example, co-owner of the debt of co-creditor. So, what else? If the sale is to a creditor, so lawful basis for the assignment, as the assignee cannot be considered as a vendee of a right in litigation and as a speculator. It refers to a dasyon and pago. So, dito sa letter B, hindi kasi speculative yung pagbilin ng assignee noong credit. So, example in your book, number 1 owes number 2, let us say 10,000 pesos. So also number 2 on the other hand, number 2 also owes number 3 10,000 pesos. So remember here na si 1 may utang kay 2, si 2 naman may utang din kay 3. So let us say class na itong si 2, instead of paying itong si 3, anong gagawin niya? Yung credit na meron siya against number 1, yung credit which he has against number 1, he will assign to number 3. So, imbis na itong si number 1, later on, kung magbabayad si number 1, imbis na babayaran niya si number 2, ang babayaran niya is direkta ng si number 3. So, here, remember class that itong si number 1 will have no right of redemption against number 3. Bakit? Kasi itong si number 3, hindi siya pwedeng makonsider as buyer of a right under litigation. So, ang kasing bumabagsak talaga dito is that this is a dasyon in pago. So, yung utang ni 2 kay 3, di ba, is a debt in money. But remember, ang ibabayad ni 2 kay 3 ay hindi pera, but a property, which is yung right niya to collect against A, or ang ibebenta niya is property na yung credit. So yun ay actually in the nature of dasyon and pago. So that is what you have to remember, because I've already discussed dasyon and pago class. So in dasyon and pago, remember, yung a debt in money is paid by alienation of property. So dun nalalaglag yan. So here in letter C, the reason for the exception, the reason why there is no right of legal redemption is because the assignee is moved by a desire to preserve the property and not to speculate at the expense of the debtor. So the usual example, this is the example in all the books that I have read. Debtor owes creditor a certain amount, let us say 10,000 pesos, and this is secured by a mortgage on the property of the debtor. So, nangutang si debtor kay creditor, meron siyang collateral, lupa. So, yung lupa belongs to the debtor. So, anyway, habang hindi pa nababayaran itong utang na to, while the property is still mortgaged also, binenta ni debtor yan kay, let us say, kay buyer. Yan. So, binenta niya kay buyer. So, remember, the property is in the hands of the buyer now, but subject to the right of foreclosure, which is available to the creditor. But pagka hindi nakabayad si creditor, ay si debtor, syempre si creditor may foreclose on the property already belonging to the buyer. In the meantime also, this buyer is able to acquire the credit of the creditor against the debtor. So, hindi lang bastang yung mortgage property ang binili ni buyer, nabili rin niya even the credit. So, in short, class, itong si debtor, dapat kung magbabayad siya, magbabayad na lang siya kay buyer. Yan. Ngayon, tignan nyo pagka hindi nakabayad si debtor kay buyer, syempre si buyer maniningil yan, hindi makabayad. Tapos anong gagawin ni buyer? Buyer will foreclose the mortgage. Remember, the mortgage property already belongs to the buyer. So, hindi na pwede to. Because you cannot foreclose a property which you already own. Alangan naman, di ba? Parang ewan yan. So, here, actually, the mortgage right, yung collateral, parang na-impair na yan because yung mortgage property is already owned by the buyer. Yan. So anyway, take note here that the debtor does not have a right to redeem yung kanyang credit which was sold to the buyer of the mortgage property. Bawal talaga. Yun lang ang sabi ng law. Bakit? Kasi syempre gusto ng assignee here to preserve yung property and not to speculate at the expense of the debtor. So yun ang tandaan natin. Here, debtor is not entitled to redeem. So presumably, the purpose of the buyer here in buying the credit of the creditor is to preserve yung property. So anyway, that's it for chapter 8 of the law on sales. We will be discussing in passing yung last chapter, which is general provision. So anyway, please stand by for that class. Thank you and have a good day.